Okay, so let's take them one by one. I may be fast a little so that we can cover so much, and I want us to pay attention. Copyright is having a right to copy and is granted to an author or creator of original works. But copyright does not protect ideas. It protects only an idea that is already expressed in a fixed form. For example, if somebody says he wants to take a photograph of sunsets, it's just an idea. Anybody can take photographs of that. So the aspects of copyright that are protected, we have literary works, we have musical works, artistic works, cinematography, sound recording, and broadcast. I repeat, literary works, musical works, artistic works, cinematography, sound recording, and broadcast. But we need to know that titles, ideas, concept, procedure, and things related to that are not protected. Now, what are the two conditions for an idea to be protected under copyright? Number one is originality. And what does that mean? There must be a minimum display of amount of skill, labor, or judgment to produce that. Then the second condition is called fixation, which is it must be expressed in a definite medium of expression. For example, it has been written down, or it has been published in a book, or it has been recorded in one form or the other. Recording in one form or the other, whether electronic or otherwise, is what is called fixation. Now, registration is not required because immediately you have produced any work that is protected by copyright, the authorship is not in doubt. But in order to give notice to the public, so that if anybody, number one, if anybody wants to produce anything of that nature or sell, import anything of that nature, the person could be well advised that no, somebody has a copyright, and the only thing the person could do is to ask for license or assignment for use. So what is required is just notification of the work. And that is done by registration with Nigerian Copyright Commission. When that is done, the Nigerian Copyright Commission has a data bank of copyright authors, their works and names, and that constitutes a public record, which avails the author or the copyright owner to use in case he wants to file a suit against anybody that wants to infringe on his rights. Now, literary works, we have several types of them. It could be novels, plays, even computer programs, letters, and so on. Artistic work, drawings, plans, musical works, we know of that. Now, then we have broadcast, whether sound or television broadcast. What is the duration for copyright? For individual, it is protected when it is literary, musical, or artistic works. They can be protected for the lifetime of that individual and another 70 years after the person has died. But if it is a body corporate, whether a company or incorporated trustees, it's only for 50 years, 70 years from the first year of publication, 70 years for the first year of publication. But when it comes to cinematography, films, photographs, it's only for 50 years from the first year of publication. Same thing applies to sound recordings, broadcasts, 50 years from the dates of making the first recording of the broadcast. Now, beyond the authors or copyright owners, there are some rights too that are ancillary to copyrights, the rights that the copyright owners have. And we call that derivative rights. These are rights that that protect the legal interests of certain persons or legal entities that have contributed, whether creative, technical, or organizational skills, to bringing the protected work to the public. And there are three major types of them. We have performance. Somebody could write a novel. When the novel is to be performed by actors or singers or dancers, the live performance of that, there's a derivative right for the performance to enjoy economic rights that could prevent people from broadcasting or communicating to the public. What does that mean? Anybody that wants to be involved in the fixation, broadcast, or communicating that as live performances must pay the performance. The same thing applies to producers of sound recordings. The producers, because they have put in some technical works and so on, in order to make cassette recordings or compact discs or whatsoever, they have a right to authorize or prohibit reproduction or distribution of such sound recordings in order to benefit financially from it. Then for broadcasting corporations, organizations, radio, television stations, they also have a right
Sorry, I think Mr. Degede's network. I'm sure he will be right back. He will be back anytime from now. Give us a few seconds, please.
Hello, sorry for the glitch. Let me continue, please. I was saying there are two major rights. Please, are you hearing me? I want a response before I continue, please. Hello,
Okay.
Are you hearing me?
Yes.
Okay,
Yes.
I was saying there are two major rights to copyrights. Economic rights, I've defined that. Then moral rights. There are two types of that. For economic rights, you can transfer that through assignment, through license, and so on. For moral rights, you cannot. It's not transferable. And why? Moral rights has to do with the right of authorship. Nobody can debate about the author when it is written, when a particular book is written. Then there's also a right of integrity. The author of a book can object to the production of that book in an immoral way, or to translate it or to alter it in such a way that it could impugn or have negative influence on his own personal reputation. So that is what is called moral rights. Now, despite the fact that the author or the copyright owners have many rights, especially those two, there are limitations too. And the limitation is there in order to balance the society, the interests of the authors, and the interests of the society. One is free use. One is free use. What do you mean by free use? Somebody can make use of the things that are protected by copyright. Let's say, for example, books, just to make some quotations there in one's project, but one must recognize the author and the book, and so on and so forth. Then somebody can use this as the works by way of illustration, or for the purpose of news reporting, or for personal and domestic, but not non-commercial use. Personal, you can download, you can make photocopy of such book just for your personal reading. But you cannot sell the photocopy. It's not allowed in law. By doing that, you will be infringing on the copyrights of the owners. But there's something I need to let us know, which is very important. And that has to do with the status of the employees or contractors to copyright works. No, generally, when the work has been commissioned by the employer, maybe especially in artistic, literary, and musical works, the employees in such maybe newspaper, magazine, organizations cannot claim the copyrights of whatever work they produce while in the employment of such organizations, especially when the work is used for publication. However, in order not to, so in this case, it's the employer that has the copyright, but in order not to create problems between employees and employers, it's always good that there should be a clause of assignment of the works of copyrights by the employees to the employer. Because ordinarily, the author should be the first owner of the copyright of a work. Now, the same thing applies to the commissioned contractors. You paid somebody to do a copyright work for you, maybe to write a novel. You pay the person cannot claim the copyrights. But again, in order to avoid problems, there must be a written agreement, whether in the contract of employment or the contract of engagement with the employees or the contractor, in order to avoid litigation. And litigation is expensive, it's time-consuming, and creates bad feeling between people who may otherwise have happily worked together for years when that is not done. Now, let me quickly go to patents. Patent has to do with invention. An invention can be a product or a process. So the patent protects new inventions, and it covers how things work, what they do, how they do it, what they are made of, and so on and so forth. Now, examples of inventions that can be patented, they could be Android phone, computers, vehicle, electric, iron, and so on and so forth. As a matter of fact, we know some known names that have been patented. For example, microprocessors. Intel has the patent of that. Telephones, Graham Bell. Now, in Nigeria, computer software, codes, and computer programs cannot be patented. It's not a work for protection by patents. It can only be protected by copyright. That happens in this country. In some other jurisdictions, it could be. Now, there are some major conditions for an invention to be patentable. Number one, it must be new or novel. What does that mean? It means that it is not known to the public either by oral disclosure or by document disclosure, or it is not even used prior to the time you are filing application for patent rights. However, there's an exception to that. If you exhibit an invention within 6 months before filing for patent application in an official or officially recognized international exhibition, that does not amount to loss of newness or novelty of the patent. We need to take note of that. Then the second condition must be, it must result from inventive activity. What does that mean? Some efforts, some skills, some new knowledge must have been inputted into the work such that something new has been created. And it's because of this that scientific discoveries or natural phenomena cannot be patented. Also, biological processes like plants or animal varieties, things that come out of their own by nature, they cannot be patented. Then the final condition is that the invention must be capable of industrial application. What does that mean? Should be manufactured or useful in any kind of industry, including agriculture. There are two terms that I need to differentiate here, and that is true inventor and statutory inventor. Somebody that invents is called inventor. Somebody may be a true inventor, that is, the person made that invention. But if the person does not file the invention with the patent registry or the Federal Ministry of Industry and Investments, the person that files or claims priority over the invention is known as statutory inventor. And that is the person that will have the right of patent over that invention. Because the principle of patent is that somebody should not know about it before or used it before. However, the statutory inventor is obligated at least to name the true inventor in the application, especially when the true inventor assigns that invention to the person that is going to file at the appropriate registry for patents. What applies to copyrights in the case of employer, employees, contractor, and commissioning individuals or corporations or companies also applies here. There must be in the employee's contract of employment that he will not have the patent of the invention during his work in an employment. However, there's an exception there. If the invention is such that it has provided so much profit for the employer, the employee has a right for a fair remuneration or compensation. That is just that. So what I'm saying in effect is that there must always be an agreement with your employee or with a contractor that you commission to do anything for you that could result into making an invention. Now, what's the procedure for application for a patent? The procedure is just straightforward. You make an application, you describe the relevant invention with appropriate plans and drawings, you give the name of the inventor, and you submit. The patent registry would do an examination and they will confirm whether it conforms to their regulations before it is now registered as a patent. Now, there's something that we need to understand concerning intellectual property generally. And that is the fact that it has territorial application primarily. What does that mean? It is a work that you register or you give a notification for its copyright in Nigeria is the intellectual property that you register in Nigeria that you are protected on. However, there are some international conventions anyway that one can explore to have protection in some other countries. So what's the duration for protection of patents? For patent, it is 20 years from the date of filing the application. However, you must annually renew. During the 20 years of duration of the patent, you must annually renew with the patent registry. And failure to do that can result in the patent lapsing. The next one I want to talk about quickly is trademarks. Trademark protects invented words, device, slogan, label, tickets, brand, letter, numeral, company name, logo, and so on and so forth. However, there are some things that cannot be patented. If what you want to patent is deceptive or scandalous in nature, if it's the name of a chemical substance, e.g. sodium chloride, you cannot patent it. Then if it applies to geographical names in the ordinary sense, or majorly if it's descriptive in nature. What does that mean? You cannot be growing apples and you say you want to patent apple because you're already describing what you want to patent. But you can patent a mobile phone, just like Apple has a mobile phone. No, trademark, sorry, please. You can trademark a mobile phone because a mobile phone that is trademarked as Apple, Apple in the ordinary sense of the word does not describe a mobile phone. And trademark is very important because it's a source of identity and it gives brand protection. Then people can use it in advertising, it has investment value, and so on and so forth. There are two major conditions for trademarks. For things you want to trademark to be approved. Number one, it must be distinctive. It must be unique. It must not be generic. It must not be common. Then number two, it must not be deceptive or scandalous. What is the procedure for registration? Again, you file an application through a form with the trademark registry. The trademark registry will give an acknowledgement of that application. Then they will examine the application. If they are satisfied about the fact that some things major things have been complied with, they will give a notice of acceptance. After they have searched that there's no one that is using a trademark that is similar or identical to the one you have come to apply for. Now, when you have the notice of acceptance, you are protected to a certain extent. But if after examination, what you want to trademark cannot be approved, the trademark registry can refuse it on some grounds. Those grants that are given, the trademark registry can refuse it. And they will do that. When they do that, within 2 months, one is expected to contest the refusal. But in case it is approved, the next stage is just publication in the trademark journals for the public to object or to oppose to the registration of that trademark within 2 months. After 2 months, if there is no objection, the certificate of registration will be given to the proprietor of such trademark. What is the duration of trademarks? The initial duration is 7 years and can be renewed for further periods of 14 years. And you can continue to renew your trademark, see whatever years you want. After 14 years, you can continue to renew it every 14 years. But the renewal must be done between 3 months before expiration of the initial duration that was approved for you and 3 months after expiration. Failure to do that, it goes into public domain, meaning that you have lost the right of trademark and somebody else can use that and register. Now, there are some grounds by which a trademark can be revoked. Number one is non-use. If before you register, you apply for registration of a trademark, a month before you apply, you have no intention to use the trademark, or even after 1 month, you don't use it, it will be assumed that you don't need it, you don't want to use it. And most especially after registration for a continuous period of 5 years, if you don't use it, it can be revoked. What do you mean by non-use? Not on your letterhead paper, no publication of it, not in anything that people will see. It means non-use. Then it can be revoked because of non-renewal. If you don't renew within the period, then if you register it, if you obtain registration by fraudulent means, it can be revoked. Or if it is likely to cause confusion, or is scandalous, or is contrary to law, it can also be revoked. Now, an unregistered mark can acquire some level of protection too. And the way that can be done or enforced in Nigeria is what is called by passing off. What does that mean? If you have used that mark for a long time, many years, and it has been notoriously used so that people know it very well, and it has established goodwill and reputation attaching to the goods or service by which you use it. If somebody wants to use it,
Wow. Sorry for that. I'm sure it's a network issue. It will be resolved in a GV. Please just hold on. I'm sure Mr. Jegede is going to switch to another network now. That's one of the things we experience around here. So it will be resolved in the next few seconds. Just please bear with us. Mr. Jegede is going to be back in the next few seconds, please.
Hello.
Yes, you're welcome back.
Wow, sorry for the glitch.
No problem.
Now,
sir.
for industrial design, it protects ornamental aesthetic aspects of an article. What does that mean? Just the appearance. It consists of three-dimensional features like shape of an article, or two-dimensional features like patterns, lines, or colors, or combination of those three, the patterns, colors, and so on. An example of products that can gain protection by industrial designs, they could be technical or medical instruments, watches, jewelry, electrical appliances, and so on and so forth. Now, I need to explain there's a difference between industrial design and patents. And what is the difference? Number one, industrial design protects only the appearance or the aesthetic features of a product, whereas a patent protects the invention itself. The invention itself that offers the technical solution to a problem. That is the major, because the invention itself has some functions, the technicalities. Unlike for industrial design, that is just the appearance or the aesthetic features that will be protected. There are two major conditions for registration of industrial designs, and very similar to trademarks. It must be new. And what does that mean? Not available to the public before, and the public does not have prior knowledge of it before bringing it up for registration. That must not be contrary to public order or morality. The registration procedure is similar to that of patents. Application to the Register of Patent and Design. You submit the specimen of the design, photographic or graphic representation of the design. Then you must specify an indication of the kind of products for which the design will be used for. The reason for that is that, for industrial design, oftentimes, when you are coming to apply for registration, you're making a model, a pattern, from which you now make mass production of it later. And just as I said, concerning trademarks, and concerning patents, the employers and the contractors, they must have an agreement with the employees or any person they commission to produce the design that you want to register. What is the duration? It's 5 years in the first instance, and it's renewable only for 2 further consecutive periods of 5 years, making a total of 15 years. After that, it goes into public domain. Now, for all these IP rights, there are some remedies if somebody infringes. What do you mean by infringement? If somebody imports such, sells, translates, or deal with it in any way without your consent or authorization, haven't gotten registration of such, you can claim for damages, which is just financial compensation. You can apply, you can take legal action and get some orders from courts. One is injunction. Injunction is stopping the infringer from continuing to infringe on your rights. You can claim, the court can order when you claim for account for profit, whatever profit the person could have made. But this must be, you must give facts as to this. The profits, the court will order that the profit should be paid back to you. And there's this order of the court that is called Antopila order. There's another of courts that will give you a right to go and search the premises, though with law enforcement agencies anyway, and seize or destroy all suspected infringing goods, including the equipment with which they use, equipment and materials to manufacture such counterfeits or infringing products. Then there could be criminal sanction too, when it is reported to law enforcement agency. Criminal sanctions could be either a fine or imprisonment or both. The last type of IP protection I want to talk about is trade secrets. You know, I mentioned that from the beginning of this presentation. What is the trade secret? It's a formula or a process or device or other business information that is kept confidential to maintain an advantage over competitors. And I hope that the information could be a formula, it could be a pattern, it could be a program, even it could be a device or method or technique or process. However, not all inventions can be protected. No, those such inventions that you cannot protect by patents, you can protect by trade secrets. And what are they? Like scientific theories, full recipe, as we mentioned, mathematical methods, commercial methods, even information about your clients, customers, and so on, such that somebody will not pitch them from you. And these secrets can be divided into two. One, protect invention and manufacturing processes that do not meet the patentability criteria, which I mentioned, the manufacturing process or customer list and so on. The other one could be even those inventions that fulfill patentability criteria that can be patented, but you still want to protect by trade secrets. Now, what are the factors that qualify confidential information to be protectable by trade secrets? Number one, because it's a secret, it will not be generally known to the public. Number two, it must have commercial value, and that's why you don't want to disclose it. And number three, it must be subject to reasonable efforts by the holder of such information to maintain secrecy. You know, unlike the other intellectual properties, such secrets are not statutorily protected in Nigeria. There's no law that backs it that, like the other IP rights. And because of that, they are not registrable. But the good thing is that if you can protect secrets indefinitely, as long as it is not disclosed. And I hope we know that this is the last thing I just want to say now. Some things can be protected with 2 or 3 IP rights. For example, if you make a computer program, you can protect it by copyright, the computer program. Then your company, in the process of selling the computer program, can also protect it under trademarks. And this is the company that is selling it. Now, having said all this, it is important that when you have an idea, because it is very valuable, and the idea, when it is expressed in a fixed form, it becomes an asset. There is a need to take steps to protect and have rights to enjoy maximally whatever expressed idea that you have. On this note, I want to stop here for questions. Thank you. Pastor Segun.
Hello, sir. Thank you
Yes.
so much. Thank you so much for the expository delivery. I'm sure many people have learned so much tonight, and it's so amazing that many of us do not have access to some of this information before now. I mean, we just do things and then run things anyhow. I mean, I've seen people who said they want to write books, they want to publish books, but who don't have an idea of how to do a copyright for their books and ideas. And then, like I said, a lot of people have lost money before now. So thank you for opening our eyes to some of these opportunities, some of this information tonight. I'm going to ask us, I'm not sure we have any question in the chat box, in the chat room, no question. I'm going to ask, in case there's anyone who have a question to ask Mr. Jegede tonight before he goes, you can signify by, I want to say by a wave offering. So we have 10 minutes for questions. You can signify by raising your hands. There is a place you can raise your hands here in the on the platform so that you can, I call you up and then ask you to unmute and then you can ask your questions. So we have 10 minutes for this and then we can close tonight. It's a brief, short interaction just for us to have the awareness of how to go about. I would ask Mr. Jegede to please send his, just in case you need to reach him after now, his email address, possibly his phone number if you want to send to you or you want to send a message to him. You can send, Mr. Jegede, can you please help me send your email address and your phone number in the chat box so that those who are connected tonight can copy and then reach back to you after now. So if you have questions, the floor is open for your questions. Floor is open for your questions. Anything you want to ask in line with our discussion tonight, not just anything. I mean, don't ask questions about who is going to win election next year. I mean, that's not what we're discussing tonight. So you have the email address of Mr. Jegede. You can copy it just in case you need to reach him after now. Just in case you need to reach him after now. Any questions? Any questions? Any questions? Okay, let me check. Okay, you have his phone numbers. Any questions? No questions. It's going and it's going and it's going and it's going and it's going. Okay, so since there are no questions, let me quickly appreciate our guest speaker tonight, Mr. I wanted to call him Barrister Seyi Jegede, for the information passed across tonight, opening our eyes to see the importance of patency, the importance of trademarking, copywriting, your ideas. A lot of us have wonderful ideas, but we don't know how to go about it. And then you see your ideas somewhere else being executed, but there's nothing you can do about it because you don't have trademark for it, you don't have copyright for it, you have not patented it, so you don't have anything on no legal ground to fight for anything. So thank you, Mr. Jegede, tonight, and let me quickly appreciate all of us for joining in tonight. My Oga was here before, Mr. Benga Oyekon is gone. Thank you for joining. Ibukun, thank you. Adewale Adekunle, thank you for joining. AB Multimedia, God bless you. Thank you for joining my people at the business school. John Akinsola, Joseph, Mr. Olaoluwa, thank you for joining. Matthew Olamide, thank you. Kayode K. Saka, God bless you. Samson Oguntoye, thank you for joining. Technospark, thank you for joining. Thomas Olutubosun, thank you for joining tonight. I mean, this is one of the things we do at the First World Business School. This is just a build up to what we learned in the school in the last month. I mean, this is just one of those things that we learned. So we're going to have this again and again after now. We're going to have this again and again after tonight. Will let us know and get the information passed across to us on any other important information that we will need us to be abreast of as we move on. So I wish you the best of God tonight. Enjoy the rest of your day. Have a sweet dream as you sleep tonight. So this is how far we can go tonight. It's just a short, brief discourse. And then we move on from here. Thank you, everyone, for joining. I will ask you to unmute your mic. Let me see. Ask you to unmute your mic. So you can we can greet each other. I mean, so basically the service is over. That's the implication. Thank you everyone for joining tonight. I appreciate you. Thank you for coming. Thank you for coming, everyone. Thank you for coming. We hope to see you after now. After today, we have to see you again and then send you invites for subsequent portion. Thank you, everyone, for coming around. And then I believe you've been impacted tonight. Mr. Jagade, thank you. We'll appreciate you. Thank you for spending your time with us tonight. God bless you. We'll appreciate you. So this is the end of our discussion. I see you after now. So enjoy the rest of your evening and then excel and move up the ladder in everything you do. God bless you. Thank you. And then I see you after now.